Imagine being put on a plane by the government, but they are not sending you to your home country. They are sending you to a country you have never been to, a country where you have no family, no connections, no history. You are given 6 hours notice. No one asks if you are afraid. No one tells you where you are going. And when a judge rules you are protected from deportation to one country, the government puts you on a bus to another country where you were raped, and from there sends you straight to the country the judge said would persecute you. This is not a hypothetical. This happened, and a federal judge just said it is unconstitutional. Welcome to U.S. Immigration News Daily, your source for verified updates and clear guidance on United States immigration. I cover USCIS updates every Monday, Wednesday, and Friday at 2 p.m. Eastern. If this is your first time here, subscribe so you never miss a critical update. Let us get into it. On February 25, 2026, United States District Judge Brian Murphy in Boston issued an 81-page ruling that declared the Trump administration's third country deportation policy invalid. The judge wrote, "It is not fine, nor is it legal." This is one of the most significant immigration court decisions of 2026 because it directly addresses whether the government can remove someone to a random country without telling them where they are going and without giving them a chance to object. Here is exactly what happened, who is affected, what the ruling means, and the 5 things you need to know right now. The case started in March of 2025. 8 people with final orders of removal were loaded onto a plane. Their removal paperwork listed their home countries, but the government did not send them to their home countries. Instead, the flight was headed to South Sudan. Then, the destination changed. They ended up in Djibouti. Neither South Sudan nor Djibouti appeared on any of their removal documents. These 8 individuals had no ties, no family, no history in either country. Immigration advocates filed an emergency lawsuit in Boston challenging the practice. Judge Murphy initially issued a preliminary injunction in April of 2025. That injunction required the government to provide written notice of the third country before deportation and give people a meaningful opportunity to raise fears of persecution or torture in that country. But the government did not follow the order. In May, Judge Murphy found that the administration violated his injunction when it tried to remove a group of men with criminal histories to South Sudan with less than 24 hours notice and no chance to raise fear-based claims. Those men were from Cuba, Laos, Mexico, Myanmar, South Sudan, and Vietnam. None of them had South Sudan listed on their removal orders. The case went to the Supreme Court. In June of 2025, the Supreme Court sided with the government and lifted Judge Murphy's injunction, allowing third country deportations to resume while the case continued. If you are finding this information valuable, tap the like button right now. It helps this video reach more people who need to hear this. One tap from you could help someone understand their rights before they face removal. After the Supreme Court's decision, ICE issued new guidance in July of 2025. That guidance is the policy that Judge Murphy just struck down. Here is what the ICE policy allowed. Immigration officers could designate any country willing to accept the person, even if it was not their home country and was not listed on their removal order. Officers could execute the removal with as little as 6 hours' notice. Officers were specifically instructed not to ask whether the person was afraid of being sent to that country. If someone did not volunteer that they were afraid, no screening happened. No written notice of the destination country was required before removal. The government claimed it had received assurances from receiving countries that deportees would not be tortured. Judge Murphy rejected every part of this in his February 25th ruling. Let me break down the 5 key findings. Finding number 1. The policy violates federal immigration law. Congress established specific protections for people facing removal. The law says the government may not remove someone to a country where their life or freedom would be threatened on account of race, religion, nationality, political opinion, or membership in a particular social group. The law also says the government may not send someone to a country where they would be in danger of torture. Judge Murphy ruled that ICE's 6-hour removal process with no mandatory screening makes it impossible to comply with these congressional mandates. Finding number 2. The policy violates the Fifth Amendment Due Process Clause. The Fifth Amendment says, "No person shall be deprived of life, liberty, or property without due process of law." Judge Murphy emphasized the word person, not citizen, not legal resident, person. The Constitution protects every person on United States soil regardless of immigration status. The court found that being deported to a country where you might be persecuted or tortured is a deprivation of liberty that requires due process. 6 hours with no written notice and no mandatory screening does not meet that standard. Finding number 3. The government's assurances are meaningless. The government argued that it obtains assurances from receiving countries that deportees will not be tortured. Judge Murphy dismantled this argument. He wrote, "Nobody really knows anything about these purported assurances." The court found that the assurances were vague, unverifiable, and did not address individual circumstances. A blanket promise from a government does not protect a specific person who faces persecution for their religion, ethnicity, or political beliefs in that specific country. Finding number 4. The government lied about compliance. Judge Murphy documented specific cases where the government violated its own policies and court orders. In one case, a man identified as OCG was granted legal protection preventing his deportation to Guatemala. The government's response was to put him on a bus to Mexico, where he had previously been raped, and from Mexico he was quickly sent back to Guatemala, the exact country a judge had found he would likely be persecuted in. Judge Murphy wrote that the government then lied about it. Finding number 5. The ruling is paused for 15 days. Judge Murphy stayed his own decision for 15 days to give the government time to appeal. This means the ruling does not take effect immediately. The 15-day window started on February 25th, which means it runs through approximately March 12th. DHS has already indicated it plans to appeal. A DHS spokesperson said the department is confident it will prevail if the case reaches the Supreme Court again. Now drop a comment below and tell me, did you know the government could deport people to countries they have never been to? I want to hear from you. So what does this mean for you right now? Let me give you 5 action steps depending on your situation. Action step 1. If you are currently in removal proceedings, talk to your attorney immediately about this ruling. If you do not have an attorney, contact your local legal aid organization or the National Immigration Litigation Alliance. This ruling strengthens your due process protections, but only if you assert them. Action step 2. If you have a final order of removal, understand that the government may still attempt third country deportations while the appeal is pending. The ruling is paused for 15 days. During that window and potentially during the appeal, the current policy remains in effect. Do not assume you are protected until the appeal is resolved. Action step 3. If ICE contacts you or attempts to remove you to a country that is not your home country, you have the right to object. You have the right to state that you fear persecution or torture in that country. Do not wait for them to ask. Volunteer that information immediately and clearly. Under the current ICE policy, officers are not required to ask you. You must speak up. Action step 4. If you are a family member of someone in detention or removal proceedings, make sure they know about this ruling. Information is the most powerful protection in immigration law. Share this video with them. Share it with their attorney. Share it with anyone who needs to understand what just happened. Action step 5. Watch for the appeal. This case is almost certainly headed back to the Supreme Court. The Supreme Court previously sided with the government in June of 2025 by lifting Judge Murphy's earlier injunction. Whether the Supreme Court will uphold or reject the full ruling on the merits is an open question. I will cover every development on this channel as it happens. If you watched my earlier video on TPS terminations, you know that courts and the administration are fighting on multiple fronts right now. I will link that video in the cards so you can see how TPS, asylum work permits, and now third country deportations all connect to the same enforcement strategy. Here is the bottom line. A federal judge has ruled that the United States government cannot deport people to random countries without telling them where they are going and without giving them a chance to object. The judge said the Fifth Amendment protects every person on American soil. The government says it will appeal. The Supreme Court may take it up again. And 15 days from now, everything could change. This is one of the most important immigration rulings of 2026. If you are in removal proceedings, if you have family members facing deportation, if you are an immigration attorney, if you are an employer with workers in immigration proceedings, you need to understand this decision. Subscribe to U.S. Immigration News Daily and hit the bell so you are notified every Monday, Wednesday, and Friday at 2 p.m. Eastern when I post new updates. Share this video right now with anyone who needs to understand their rights. Send it to your family. Send it to your attorney. Send it to your community group. Post it on WhatsApp. The more people who understand their constitutional protections, the safer everyone is. This video is for informational purposes only and does not constitute legal advice. Consult a qualified immigration attorney for guidance specific to your situation. I will see you on Friday with the March 2026 Visa Bulletin Breakdown. EB-2 just went current for the first time in years, and hundreds of thousands of people can now file for their green card. You do not want to miss that one. I will see you then.